The halls of justice were bathed in the soft, amber glow of the morning sun as it filtered to the high, arched windows of the courthouse. There was a unique stillness in the air, a quiet anticipation that always preceded the unraveling of human stories. Within these walls, the complexities of life were brought before the steady gaze of court, where truth was sought with patience and wisdom. This was the stage for a new chapter in the long history of human disagreements, a place where clarity would soon replace confusion. The doors of the courtroom swung open with a gentle creak, admitting the participants of the first case of the day. Gabrielle Alpertson and her mother Angela walked toward the plaintiff's table with a mixture of nervous energy and determination. Across the aisle stood Glenn Garaciano, the man who had once been their landlord but was now their legal adversary. The bailiff called the court to order, and all present rose as a judge, a woman of sharp intellect and even sharper wit, took her seat upon the bench. The judge looked down at the documents before her, and then turned her attention to the young woman standing at the podium. She began by asking if Gabrielle had boarded her horses with the defendant. Gabrielle confirmed that she had. The judge, sensing the tension, noted that the arrangement had evidently not worked out. Glenn Garaciano quickly added that it was much more than a simple failure of expectations. The judge, with a practiced calm, reminded everyone that while patience might be lost, the case was just beginning. This was the matter of case number 3028, Alpertson versus Garaciano. The judge greeted them with a professional courtesy and began to gather the facts. Gabrielle, who was 21 years old, explained that both she and her mother owned horses. In February 2023, they had moved their animals from Charlotte, North Carolina, to the historic city of Charleston. They had brought both horses together because the animals had been companions for over 6 years. It was a shared passion between mother and daughter, a way to stay connected as Angela planned her own move to join her daughter in Charleston. Gabrielle had been the one to find the property and meet with Glenn. She had ultimately signed a lease at the beginning of February 2023. When the judge asked to see the lease, there was a brief moment of modern frustration, as Gabrielle explained it was on her phone via email. The judge, preferring the tangible nature of paper, requested a copy. Glenn stepped forward, offering a packet of documents which he called Exhibit Bravo. The judge focused only on the lease, setting aside the rest of the paperwork for the moment. The lawsuit was a quest for the recoupment of money paid under the lease. While Glenn had filed a cross-complaint for damages he alleged the horses had caused to his property. The lease had officially started on the 12th of February, but the horses had arrived on the night of the 11th. Glenn had been present to welcome them, showing them where to find the water troughs and how to manage the basics of the pasture. There were no incidents that first night. Glenn had made it clear that he had no knowledge of horse maintenance, and the responsibility for the animals' well-being rested entirely on the Alpertsons. In that first month of February, the Alpertsons had paid $925,000. The judge questioned the amount and the purpose of the payments. Gabrielle explained that they had made 3 payments of $925,000 in total. One payment was for the security deposit, and the other was for the first month of boarding. By the time they were forced to move on the 13th of March, they had paid for a second month as well. The horses had stayed for a total of 5 weeks before the situation became untenable. The judge observed that the relationship had ended with both parties being happy to part ways. Now, the only remaining issue was the financial settlement. The Alpertsons wanted their security deposit of $925,000 back, while Glenn insisted that the money should be kept to cover the damages to his pasture. Glenn mentioned allegations of criminal animal abuse, but the judge quickly moved past those claims, focusing instead on the tangible evidence of property damage. Glenn expressed his frustration, stating that his life was fleeting by too fast for such disputes. He handed a document to the court assistant, Kevin, who then showed it to Gabrielle. The judge asked Gabrielle to identify her signature on the paper. Gabrielle looked at the document and confirmed that she had signed on the day they left the property. The judge read the document aloud. It served as a receipt for the rent and the deposit, and it explicitly stated that the parties had agreed the deposit of $925,000 would be forfeited to cover some of the damage done by the horses. The judge looked at Gabrielle and explained the legal reality. By signing that document, Gabrielle had entered into a contract. She was 21 years old and legally responsible for her decisions. The agreement to forfeit the deposit in exchange for leaving and ending the lease was a binding one. Gabrielle tried to explain her side of the story, wanted to delve into the details of the incident, but the judge remained focused on the law of contracts. The document was an acknowledgement that the horses had done damage and that the deposit would be kept as compensation. The judge noted that the word sum in the agreement was particularly significant, as it suggested that the deposit might not even cover all the damages Glenn was claiming in his countersuit. Despite the emotional weight of the situation and the Alpert son's feelings of being harassed, the judge remained impartial. She dismissed the case, concluding that the signed agreement settled the matter. The court was adjourned, and as the parties left, Gabrielle and Angela reflected on the difficulty of the experience. Angela mentioned that they had felt something was wrong from the beginning and had worked quickly to get the horses to safety. Outside the courtroom, the judge shared a moment of reflection with her assistant, Sarah. They discussed the difference between legal arguments and emotional ones. The courtroom often served as a therapeutic space for people to tell their stories, but the final decision must always rest on the evidence and the law. In this case, the contracts were clear. The word sum had been a slick addition to the agreement, allowing the landlord to retain the deposit while still leaving the door open for his own claims. It was a reminder that for $925,000, one could buy a lot of grass seed, and the law would not require more than what was fair. The court then prepared for case number 2203, the matter of McCauley versus Wadsworth. Susan McCauley took her place, suing her neighbor Ed Wadsworth for towing fees and vehicle damage. This case was born not from a formal lease, but from a neighborly act of kindness that had gone awry. Susan knew Ed through a mutual friend. Ed lived with his girlfriend of 12 years, a relationship that the judge noted with a touch of humor. Some months ago, a friend of EDS had rescued a beautiful dog named Snowy, a dog that looked like he was born to pull a sled through the wilderness. Snowy had become a beloved member of EDS' household, even featuring as the screensaver on his phone. The trouble had started in January, when Snowy managed to get loose and disappeared into the winter landscape. Ed searched for hours but could not find him. Desperate, EDS' girlfriend had reached out to Susan, asking for her help and suggesting she bring her own dog to assist in the search, hoping the two animal friends would find each other. Susan had agreed to help. She drove her Honda Element to EDS property, but the ground was a treacherous mix of ice and mud. In her attempt to assist, her vehicle became stuck. Ed, trying to help her, also got his truck stuck in the same muddy mess. It was a classic example of a good deed leading to an unforeseen complication. A tow truck was eventually called to the scene. The driver used a long cable to pull both Susan and Ed out of the mud. Susan had paid the entire bill of $330. Now, she felt that Ed should be responsible for at least half of that cost, as well as the damages to her car. The judge listened as Susan described the situation as a case of no good deed going unpunished. She had volunteered her time and vehicle to help find a lost pet, and it had cost her money and stress. Ed, however, argued that he had not directly asked for her help and that the tow truck driver had told him things that the judge was not interested in hearing. The judge focused on the sheer reality of the situation. Both vehicles were stuck, and both were rescued by the same service. She explained to Susan that legally, Ed was not responsible for the damage to her car, as she had been the one driving it when it became stuck. However, the towing bill was a shared expense for a shared problem. The judge ruled that Ed owed Susan $165, which was half of the total tow truck bill. She emphasized the importance of being grateful for help and the principle of splitting a cost that benefited both parties. The dog, Snowy, had fortunately been found and was safe at home, though he had sadly lost a leg due to an injury sustained while he was missing. As the second case concluded, the judge and Sarah reflected on the simplicity of the solution. When a bill is for two cars, the most logical and fair answer is to split it down the middle. Susan felt that the principle had been upheld, and Ed, despite the cost, was grateful that his dog was safe. The courtroom began to empty as the participants moved back into their lives. The day had provided a glimpse into the diverse ways people find themselves in conflict, and the steady hand required to guide them toward a resolution. Whether it was the boarding of horses or the rescue of a lost dog, the lessons of the day were centered on the importance of clear agreements and the enduring value of human kindness, even when it comes with a price. The sun continued its journey across the sky, casting new shadows in the courtroom. The gavel had fallen, the words had been spoken, and the path forward had been cleared. In the end, it was not just about the money or the damages, but about the understanding that life is a series of interconnected stories, each requiring a bit of grace, a bit of humor, and a firm foundation in justice. As the last person left the room, the stillness returned. The stories of the day would be recorded and remembered, serving as reminders that even in the most difficult moments, there's a way to find fairness. The judge prepared for the next set of challenges, knowing that with each case, she was helping to weave the fabric of a more just and compassionate world. The narrative of the two cases showed that life is full of unexpected turns. From the pastures of Charleston to the muddy fields of a neighbor's yard, people strive to do what is right, even when the path is not clear. The Alpert sons would move on with their horses, and Ed would continue to care for Snowy. The lessons learned in the courtroom would stay with them, a quiet reminder of the power of the law and the resilience of the human spirit. In the grand tapestry of human existence, these moments of conflict are but small threads. Yet, when handled with wisdom and a touch of humor, they can lead to a greater understanding of ourselves and our neighbors. The courtroom had done its work, turning confusion into clarity and ending the day on a note of hope and resolution. The pursuit of justice, much like the search for a lost dog or the care of a companion horse, is a journey that requires patience, heart, and a steady belief in the goodness of others. The final thoughts of the day turned to the animals at the center of the disputes. The horses and Snowy were reminders of the simple joys that ground us. They do not know of leases or towing bills. They only know the care and love of their owners. It is for them, and for the peace of mind of those who love them, that we seek to resolve our differences and find a way to live in harmony. And with that thought, the day in the court of Judy Justice came to a peaceful close.